Thank you so much for coming as close to the time as possible from the break. And it is not an easy task to be between a break and the next keynote speaker. My name is Muzaffar Chishti. I direct Migration Policy Institute's office at NYU School of Law. And as you can quickly see, I think my only role is to be the token male on this all-female panel. But this is a star panel to discuss the issue that was assigned for us this morning. The Secretary today laid out all the 10 executive actions that were announced in November of last year. I don't think we have ever seen this set of executive actions in one go from any administration. That itself made it a historic event. But since the actions were announced, all the oxygen has essentially been taken by the attention on DACA and DAPA, which you heard a bit about. But there were 9 other actions, as the Secretary laid out, which haven't gotten as much attention. We obviously don't have time to discuss all the 10, but for sake of brevity, we decided that we should at least handle 2 of these executive actions, which in our mind have probably have the largest import or possible import. The first, we'll talk about the DAPA and DACA executive action, which by now should have given about more than 5 million people right to stay without fear of deportation in this country and with work authorization. And then we'll talk about the Priority Enforcement Program, popularly called PEP, which is the new collaborative model between federal government and states and localities. For sake of clarity, I think we will try to keep these discussions in 2 segments. And to do this whole discussion, we really have 4 of the best people in the country to do this with us. And let me tell you why they are 4 of the best. Cristina Rodríguez is clearly one of the most influential scholars in the intersection of constitutional, administrative, and immigration law today. She is a Rhodes Scholar, clerked for Justice O'Connor at the Supreme Court, then also was the Assistant Attorney General in the Office of Counsel at the DOJ, and has taught immigration law both at NYU Law School and then was stolen from NYU to Yale, which NYU still hasn't recovered from. But her most important credential is she's a non-resident fellow at MPI.
I didn't know that.
Marielena Hincapié, who you will see sitting next to her, is considered one of the most influential immigrant rights advocates in the country. I think this doesn't bear contradiction that she was one of the major advocates who convinced the president that he should go bold and big in the executive action and convince him that he had the authority to do that. NILC uniquely deals both with important litigation issues at federal and state levels on major immigration issues and follows the enforcement of immigration law at state and local level. Heather Fong, immediately on my right, is the Assistant Secretary for Local Law Enforcement, Local and State Law Enforcement at the DHS. She came to this job after the announcement of the executive actions. So she knew what she was getting into. Before that, she had an extraordinarily distinguished career in San Francisco, where for 32 years she was in the San Francisco Police Department, in the last 5 of those as chief of police. So she came from a sanctuary city and now is convincing all sanctuary cities how they should sign on to the PEP agreement. And Dora Schriro, sitting on my extreme right, I think many of you in this room know her for being the first director of ICE's detention policy and planning in Secretary Napolitano's administration. But many of you don't know, she's probably has the most varied experience in this country on monitoring detention. She was chief of detention of the state of Missouri, of the state of Arizona, for my own city of New York, and now was chief of safety, public safety, and it's a long name.
Homeland Security.
In the state of Connecticut, where, from what I understand, she really covers the entire set of law enforcement activities in the state of Connecticut. So we are really we're pleased to have these people come from long distances to be with us today. So let's get straight to the executive action on DACA and DAPA. So, Cristina, let me ask you the first question. So we thought by now about how at least 5.5 million people would be receiving their cards. And instead, we are at a panel in the Fifth Circuit Court of Appeals. How did we land up at that panel? What issues is the panel grappling with? If you had to make a prediction, just being a good court watcher, what do you expect the decision to be? And is it taking the court suspiciously too long to make that decision?
So I think that's 4 questions, but I'll try to answer each of them. I think that the government was initially surprised that, not that it went to litigation, I think that was highly predictable, but that a district court judge last February issued an opinion as sweeping as it was, that not only found standing for the states who filed the suit, but that also found that there was a violation of the Administrative Procedure Act, which is the merits on which the district court decided the case. I think one of the things that might be happening at the Fifth Circuit right now is that they're trying to figure out exactly how to write the opinion, because the district court opinion does not provide the best template. It's a very wide-ranging, all over the place sort of opinion with very novel theories of standing and a confused analysis of the Administrative Procedure Act question with a lot of underlying constitutional atmospherics. And so it's not an opinion I think that they can rely on. But I do think based on the oral arguments, most people would predict that the panel is going to maintain the injunction. And so the question is whether and when this reaches the Supreme Court. I think there is an increasingly good chance that it actually won't be heard by the Supreme Court until next term. The litigants would have 90 days after a Fifth Circuit opinion comes out to file a petition for certiorari. And even under an expedited process, there's not that much time left for the court to grant a petition to actually hear it this term, which therefore substantially raises the stakes. And to me, there are incentives on both sides for the court to take this question. I think they will have to take the case because the district court has enjoined a major federal program on a novel theory of administrative law, and along with that, introduce novel theories of standing into case law. But I think it's a very divisive issue, and not only is the Administrative Procedure Act question messy and unclear, I think the constitutional question that they would probably address if they found there wasn't an Administrative Procedure Act problem, it does not lend itself to clear doctrinal rules. And I don't know that the court will want to get into this territory. But for that reason, I think if they have the opportunity to make it go away by waiting for the election to happen and seeing what then happens in the election, maybe a Republican administration would decide to abandon it, they might hold their decision-making process. I do think if the court decides the case on the merits, like Dora said in the last panel, the court is likely to be on the government's side. The constitutional question is very much on the administration's side, because I think it would be very easy for them to write an opinion suggesting that this is a form of structuring prosecutorial discretion that may appear novel, but is actually just a way of organizing the executive branch's power to decide how to enforce the law. And they can point to substantial evidence that, in fact, the administration has been enforcing the law. And so it's not a question of non-enforcement, it's a question of prioritizing enforcement. And so that opinion would be very easy to write. And the notion that the executive has broad discretion in this domain is consistent with the court's opinion in Arizona versus the United States. That was a very important piece of that opinion. Even though it was about preempting a state law, it was also about the power of the president and the executive branch to decide how to enforce the law. If the court were to decide that the administration had in fact violated the Administrative Procedure Act, and what that would mean is that the administration ought to have provided notice to the public and given the public an opportunity to comment on DAPA before implementing it, that would not be a disaster because it's something the administration could go back and do, though there again timing is crucial, and it would be essential for a Democrat to win or for a Republican to also continue with the program and then go through that process. I do, however, think that an APA ruling that forces the government into notice and comment with something like this, which is, again, structuring the way it uses its enforcement power, is bad for the administrative state as a whole. And so I would hope, as an observer, that's not what they would do. But from the point of view of this policy, it would not be the disaster that a constitutional holding would be. But a constitutional holding, I think, is unlikely. I should end with the caveat that no one thought that the court was going to find that the Affordable Care Act was not within Congress's commerce power and save it by finding it was in the taxation power. So we all have blinders on, even when we think we're acting like judicious lawyers and analysts. So it's very possible that these arguments will persuade enough of the justices, but I doubt that they will.
So staying just on the ACA versus versus Arizona, I think everyone salivates about the answer to the question of where do you think Justice Kennedy is going to be on this if he continues to remain the fifth critical vote. Given his position on immigration issues, where do you think he comes down on this?
So I think that he could come out one of two ways. There's a theory of enforcement discretion in his opinion in Arizona that suggests that federal law is not just the statute that's enacted, but it's the way the executive branch decides to enforce the law, and that Congress is aware that the executive branch is going to have to make choices about how rigidly to enforce employer sanctions or how not to enforce employer sanctions. And if you take that theory and generalize it from the specific parts of the statute he was looking at, it gets you to DACA and DAPA, I think, without trouble, especially since Kennedy will be able, if he wants to point to evidence of high levels of enforcement in other domains. So he can easily insulate the opinion from a charge that there's been abdication by the administration. At the same time, he's unpredictable, and it may be that, like a lot of the critics of DAPA, something feels different about this to him, and that feeling that there's somehow a benefit being conferred and there's something that's legislative in character could push him in another direction. That's not what I would predict he would do, but that feeling is palpable enough among the general public that it's possible that that's how he'll see it.
Yeah. Before I move to Marilyn, the last one on you. I mean, this is obviously a highly political charged case, and we are coming almost close to this administration. And even if the Fifth Circuit rules in time for it to go to the Supreme Court in time, there always is slow walking at the Supreme Court. Tell us, how does the Supreme Court slow walk?
Well, they could schedule the argument as late in the calendar as possible, and then they could deliberate. They won't deliberate with each other because they tend to just have a single conference on issues. But within chambers, there could be ongoing deliberation, circulation of multiple iterations of opinions, and the process itself could drag on, especially if there's no strong or clear view. The other thing they could do, and I don't know what criteria need to be in place for this to happen, but if they get the cert petition, they could continue to relist it if they can't get 4 votes to decide to take it, if there are enough people who are hesitant. And they can relist for a long enough period of time that it could basically be held over into the next term. I don't know how often they are strategic in that sense, but if it's something that they feel might be altered by the election and then the incoming new administration, that might be best for them not to issue the first ruling of its kind on the scope of prosecutorial discretion right at a time when the program itself might not actually go into effect. So they could use those kinds of delaying tactics.
Great. So, Marielena, well, you're the one who convinced the president that you should go big and bold, and he has the authority to do it. And now we are at half mark exactly between the announcement and the end of his presidency. So is the big and bold fast slipping away from one of his achievements?
So I guess I would just first start, Moose, by first thank you, and thanks to MPI and Clinic and Georgetown for this amazing conference and for all of you being here. I singularly did not do this. I did it along with millions of immigrants, especially those that are undocumented, that were so courageous to put their lives on their line, to actually engage in hunger strikes, in civil disobedience, to hold rallies. I mean, the level of courage that domestic workers, that day laborers, laborers, that undocumented mothers, that children engaged in over the last couple of years to finally get the president to be bolder than, or as bold as they were, is really significant. And I think it really does, it's a really difficult moment. It's a very difficult moment for the immigrant rights movement because we fought for and won one of the most significant immigration policy victories in recent decades. And here we are stuck in legal limbo as a result of Judge Haenen's decision in Brownsville, Texas, right? The fact that one judge in the Deep South can can be the one who blocks the ability for 5 million people to come forward and be part of even a greater part of our society. The delay is already having significant, devastation impact on the community. Every single day that we have a delay means that individuals continue to live in fear and instability, and I'll talk a little bit more about that. But just a couple of points on the timing that Cristina shared. I think we at the National Immigration Law Center have been working vigorously on the legal defense. The Department of Justice obviously is representing the administration, but we believe that this is as important for the movement. This is not simply about the legal issues at play, and it's also not just about President Obama's legacy. It really is about the 5 million U.S. citizen children whose parents are eligible for DAPA. They are the direct beneficiaries of these programs, of this executive action. And we believe, and we've been working very, very hard along with a broad sector of litigation allies, especially Supreme Court litigators who have litigated before the Supreme Court outside of the immigration context, to really try to think through what is the campaign before the Supreme Court. We think that the case, again, whether the Fifth Circuit decision comes down in the next couple of days, in the next weeks, if it does, we have a likelihood of getting before the Supreme Court this term. We've been told very directly by the Solicitor General that this is his top priority. This case in particular is his top priority, and so we will continue urging the administration that whenever a decision comes down, whether it's in the next couple of weeks or whether it's in December or in February, that the administration needs to swiftly seek cert and get this case before the Supreme Court as early as possible. I think some of the other scenarios that I would just add, or just some additional information to what Cristina shared, is that I think one scenario is that the case is heard before the Supreme Court this term. And again, we are urging the administration to use every tool at its disposal to expedite this, and for the Solicitor General to ask for shortened briefing schedule, for example. We as amicus briefs, and many of you in the room who will be working with us on amicus briefs, whether it's on behalf of law enforcement leaders, educators, former INS commissioners, et cetera, we're willing to take a shortened timeline if it means that we can get this heard before the Supreme Court. It's possible that even if the decision from the Fifth Circuit doesn't come till later, that there are ways for the Solicitor General to ask the Supreme Court to add additional argument days to try to get it and squeeze it in the springtime. But it's definitely a fact that every single day that happens, though, the more delay there is, the less likelihood that this Supreme Court will be, that this term, that the case will be heard this term. And so then we would be looking at the next term, and it's one scenario is that the Solicitor General gets to argue the case, let's say in October or November, but the Supreme Court holds off on a decision until after the elections, and possibly even in 2017. So the livelihood of 5 million people are on hold. Again, for us in particular, and I think for Justice Kennedy, who cares a lot about the impact on children and on families, the humanitarian impact is very real. I'm just going to share briefly to give you a very real sense of what the impact is on children. So for the children that today, the U.S. citizen children whose parents are eligible for DAPA, what it means for them is that they continue living in fear, despite the enforcement priorities, and we'll talk about that in a few minutes. And I'm going to share a note that a mother shared with me a couple of weekends ago. This is a note she found from her 13-year-old daughter. Now, her father had been detained by ICE a couple of years ago, and he's still in the U.S. because they're fighting his deportation. And this 13-year-old daughter wrote a little note that says, "My secret was that I don't want the ICE police to get my daddy anymore." And she draws a little picture of a house and ICE handcuffing her father and her father crying. I mean, a 13-year-old I would hope that a 13-year-old's secret is that she's secretly feeling butterflies in her stomach because she likes a boy or a girl in her school, or that she's secretly hoping to become an astronaut or a lawyer, or the president of the United States. But the fact that this 13-year-old's secret is that she's suffering the trauma of whether her father is going to get picked up by the ICE police again. And you query whether ICE or police, because that's the next part of our discussion. Both of them are having this traumatic impact on children in our country, and that is going to have devastating impact for our society for decades to come.
Okay, let's take the optimistic view and hope that the Supreme Court gives a ruling in June of 2016, which is, I guess, by all accounts, the earliest there'll be a ruling, and lets the program go ahead. From your perspective, Marielena, A, do you think the president will have the will to go ahead with implementation of this program at a very contentious election cycle? Well, as we heard from this last panel, immigration is going to become front and center, especially the unauthorized. Do you think from what you have been talking with government officials, the USCIS will be ready to implement the program in the remainder of this term? And do you think the applicants will come forward when they hear all the rhetoric in the election debate about how the next president is completely opposed to it?
So great questions, and I realize, again, you've given me 3 questions and wrapped up in one. So best case scenario, I think Matt actually talked about this earlier. It's a very similar scenario to 2012, pre-presidential elections. President Obama, candidate Romney, 2 very different visions for the country. You know, who knows who the 2 final candidates will be in 2016 in the summertime. So I think it's a very similar climate. I do think that the president will go out fighting and will go out ready to implement the program in the summertime. DACA Plus was almost ready to be implemented. The application was ready. It was a day before the day after the decision came down, it would have been implemented. So I do think that at least for the expansion of DACA, I would hope that USCIS is ready to implement that within days or a week of a decision coming down from the Supreme Court. DAPA is going to take some weeks, hopefully not months. And we, as advocates and our wonderful friends at USCIS, who I see some of them here, will know that we're going to work. We are partners, and we were able to respond. When DACA was announced on June 15th and implementation began on August 15th, we, as the immigrant rights movement, organized and got ready. We rolled up our sleeves immediately and got it done. And so we will do the same on DAPA. The stakes are too high for it not to go into effect. So I think it will take a lot. It'll take a village. It'll take a village for all of us to get together, work both public and private sectors to ensure that the implementation can happen. And then the last question about the election and whether people will come forward, I think, again, we're going to see something similar to DACA. It will infuse hope in the electorate. I think it actually will serve as a kind of a jump starter and get a lot of people out to protect DAPA and DACA Plus, because once the Supreme Court has ruled, it will be very difficult for people to say that they don't want to have a president who's going to take it away. And then second is the people who will come forward probably will be the most active members of our communities, including the domestic workers and the mothers who put their lives on the line, who fought for this change in policy. So I do think there will be hundreds of thousands who will come forward, and some people will definitely wait until the presidential election results.
Cristina, can I go back for a second to you? So let's assume it doesn't happen in June of 2015. So we're back at the next. When does this court legally become moot?
It certainly becomes moot if someone wins.
Both legally and politically.
Well, politically, I'm not sure. I think politically it probably never becomes moot, but it might also be up to Marielena and the millions of people who have organized around the issue. But I think legally it clearly becomes moot if a Republican wins the election and then rescinds the guidances on the first day in office, which is a real possibility, I think. And then it becomes moot. I think a Democratic administration would also have to make a decision about whether to continue. I imagine that that one would. I also think it's conceivable a Republican one would, though I'm not sure that would be the first act that a Republican would engage in upon entering the White House. And so I don't know what that means for the case. It may be that the Supreme Court will dismiss it as improvidently granted if the government doesn't want to continue defending it, and then the administration would be free later in time to decide to return to the program, maybe in a modified form, but having corralled their right flank to prevent litigation from preventing it from going into effect. But that's why the timing is crucial, because even if the court hears it in October of next year, in January, it could in fact become moot. And I think we've heard this, I think we heard this a bit in the last panel, but if the process can get underway, that is going to have a binding effect even on a Republican administration. Mm-hmm. So it'll be a lot harder for them to rescind the memos if people have already gotten relief or if the processing has already begun politically and just logistically. So it's crucial that something actually happen before January, but less crucial if a Democrat wins.
Well, let's assume something doesn't happen before January and we have clearly there'll be a new administration. Let's assume this is Democrat, but they have to reissue an executive action?
I think that's a good question. I don't know the formal answer to that. I think they could. It's not like a duly promulgated rule that has already gone into effect, but I think they could just adopt the same guidance as and it would go from being the Johnson memos to being whoever is the next Secretary of Homeland Security. It's possible the administration, whoever is the new Solicitor General, would have to file something at the court to say we're going to continue to defend. But I think the court would wait for the government to decide whether it was going to continue to defend the case. I don't think sua sponte they would dismiss it. But again, I suppose it's possible they would, but not if a Democrat is showing signs of wanting to continue.
Marielena, just one before we move on to the second topic. The advocates are famous now for pivoting. You pivoted from legislative action to administrative action at some point. So when are you going to pivot from the Obama administration to the next president?
Oh, pivoting is happening. Yeah, we have learned the art of pivoting, especially at the National Immigration Law Center. I think we're on plan D and E and sub 2, and actually in very active conversations right now about what the pivot is. So I think the broader movement, and many of our sister organizations are already, I wouldn't say quite pivoting because they've started the civic engagement work already, but the closer we get to the primaries, many organizations will be focused on civic engagement and getting the vote out and naturalization. To really focus on the outcome of 2016 because it had such an impact on our communities, not just on the future of DAPA and DACA Plus, but other issues like education and the economy. In terms of the pivot about what happens with respect to DAPA, DACA Plus, we are already looking at what are other litigation alternatives? If we don't have a decision from the Fifth Circuit in the next couple of days, we are already exploring other litigation options. I'll leave it at that, and you can read about it in the news. And then also administratively, what else could we be pressuring, working with the administration on in the remainder of its time? And I think a gentleman asked that question of Secretary Johnson earlier. And I think there are things that the administration can do that, especially around the enforcement issues and other issues that would make a difference in people's lives. And so I think that will be a big part of the focus as well. Really? And DACA, we can't forget 2012 original DACA continues to be in effect, and that will also continue to be a focus of ours to make sure we have enough eligible individuals applying for DACA for the first time if they haven't so far, and then renewing on time.
Great. You're not making any news. We have communications people waiting for some news event with this. So talking about pivots, let's pivot to PEP. Heather, let me start with you. When Secure Communities was announced in 2008, I mean, it was really announced as the best thing that happened since sliced bread in the world of cooperation between federal and local law enforcement. So why did the president and the secretary decide to end ESCOM, as it's popularly called, and replace it with PEP? And how is PEP different from ESCOM?
Thank you, and thank you for the opportunity to be here with all of you today. What happened under secure communities is, as it came out, some people thought it was the best thing since sliced bread, but there were many others who said, no, this is problematic. And over time, what we found is more and more state and local jurisdictions not complying with the detainers. As the Secretary mentioned earlier today, there were not only legal but political challenges that arose, to the point that basically there was a lot of inconsistency and also a lot of question about what really is the government's policy in terms of removal of undocumented individuals. And so with the executive actions, there were two that are actually intertwined. One is the one about prosecutorial discretion, about setting the priorities for this administration, and that's intertwined with PEP in that some of those priorities are really the key focus of the PEP program. Unlike the past where there was a broad brush, here we have very clear guidelines so that everyone, whether in law enforcement or at the community level, or would know this is what we're focusing on. The only thing that's similar between the former program and the current PEP program is the use of biometric fingerprint data. That continues today. So when an individual is fingerprinted, that data goes to the FBI, and it also goes to DHS for criminal background and for immigration status. So let me talk about the priorities, because that's really the key. The priorities that we are looking at are: 1, felons, aggravated felons; 2, significant misdemeanors; 3, those who, as adults, have been involved in gang activity; and 4, those who are a threat to national security. Now, just because you've been arrested for one of those crimes doesn't make you eligible as falling under PEP. In order to be under the PEP priorities, you must have been convicted of one of those crimes that falls under the area that I've spoken to. So in the past, people would talk about situations where someone was arrested, and the next thing we knew, they were removed from this country. In this new program, with the PEP program, that doesn't happen based on an arrest. There must be a conviction. In addition to those priorities, there also are 2 new forms that are being used by ICE under the PEP program. The detainers are still available, but the detainers now include probable cause for detaining an individual for only up to 48 hours beyond the time that they would otherwise be released. And these probable cause scenarios, whether they already have a final removal order from the court, whether they're pending removal orders, or other criteria where there's evidence to show that this person, in fact, there is enough probable cause to hold that person, that's a request that ICE will make to the state and local law enforcement. In the past, the 48 hours went beyond just 2 days. It went not including holidays, not including weekends. That's all off the board now. It's 48 hours total. The other form that is new to PEP is the request for notification. This form basically says to state and locals, if you would notify the ICE office up to or as soon as 48 hours prior to the person being removed, or completing whatever detained time frame they have at the custodial facility, ICE will be there to pick that individual up and transfer custody from one law enforcement agency to the other without holding them beyond the time. This way, the concerns about litigation and about holding someone beyond a violation of the Fourth Amendment would not stand. So the notification process and the detainer process. So there are 2 processes, whereas in the past, there was only the detainer. So the key here, though, is with all of these new points within PEP, is that it's not a program that works the same in all communities across the country. We know that as there are different communities and various cultural groups and desires within communities, we have to look at how do things work. This is not one size fits all. And so the difficulty in implementing the priority enforcement program is that you can't press a button today and say, tomorrow we're ready to go. We had to step back and really look at working together with the communities and state and local law enforcement. And I'm sure because of the work that you all do, you've probably heard about the engagements that have happened across the country, whether it's the secretary, the deputy secretary, the director of ICE, a number of senior leadership within DHS. We've been all over the country meeting people to not only talk about the program, but to explain that the way the program works will be the way you want it to work in your community. We have some jurisdictions that say, we agree for public safety, we feel that certain categories of individuals, certain crimes, people convicted of a rape, a robbery, a murder, those individuals should not be released back into the community. We believe that they should be removed after their time in custody. If that's the case, those jurisdictions are only complying with those crimes or those categories. Other jurisdictions say, no, we'll comply with everything. And so really, since July, the ICE field office directors have been talking with communities to work together with each and every jurisdiction to come back on board. And I will say, and I've said this in other cases, that under the past program, there were times when people were waiting for DHS and ICE to say something, and we didn't say anything. We weren't there to support the challenges that occurred. So now, under this secretary and deputy secretary, it is a partnership. We are rebuilding that partnership, restoring that trust, so that as we move forward, we can truly be implementing the program that works best in that community. And as the secretary mentioned, we have made a lot of strides. A lot of jurisdictions have come back on board, but not the way we want them to come on board, under their own terms. Some of the challenges are that some jurisdictions have legislation that actually make it difficult for law enforcement to participate. But the key is continuing to have that open dialogue so that even those who aren't ready to come on board now, we're not shutting the door, and hopefully over time, we will continue to see improvements in the program and more people decide that they do want to participate.
Thank you so much. This is very interesting. So, I mean, I think we got good sense from the secretary as to how many people have come on and all that. But if you're meeting resistance in certain jurisdictions, what is the resistance based on, and how are you accommodating them?
Well, it comes down to each jurisdiction. For instance, in one case, there are communities that say we don't want ICE in the jails at all. They're not opposed to notifying us, so then the ICE agents, do they wait outside and accept that person? In other jurisdictions, because of the legislation within their county, basically that they cannot cooperate in any way with ICE. So it really isn't the state and local law enforcement desire not to participate, but they might be in a jurisdiction where that's not possible. But again, it's not a program that's set in stone where it has to be done a certain way. With more communication, we've found that many jurisdictions have come back on board based on their terms, and we're very happy that they're willing to do that because we're willing to work the program however it works best within each of our communities.
Dora, let me move to you for a second. So you've seen this from planning point at DHS, how DHS works, and now you have seeing it in Connecticut before that you saw in New York. So does this, either from your perspective in Connecticut or what you hear from your colleagues in the state and local law enforcement, does this feel different than ESCOM is, and how?
I guess I would say, good morning, everyone. I guess I would say yes, but there's clearly a different tenor, and this sense of empathy. That was a comment made by one of the questions this morning. So we're in this together, and that's clear. As you've observed, Connecticut is one of those 340, the number that the Secretary mentioned this morning, jurisdictions that has passed legislation, and my previous employer, the City of New York, had passed an ordinance. And so where you have regulations in place, that provides policy guidance from a state perspective. I might hasten to add, though, at least in the context of New York City and now Connecticut, that the ordinance that was passed and the state statute that was passed mirror quite closely the priority one outline that is included in the new initiative, the priority enforcement effort. So there's more synergy, I believe, than there was before. There is still the fundamental tension, starting back with the one thing that is, at least the one thing that is similar between secure communities and PEP, and that is that everything starts with fingerprints, and fingerprints is that information that is collected by law enforcement at the time of an encounter, and it is the method by which we confirm identity for any subsequent encounter, and so from there you spin into a number of other social issues that have played out in the last year or so in Ferguson, a place where I served in Missouri, and of course in Baltimore, and then Staten Island, a part of New York City most recently. So there is still, depending on where you sit, if not a real tension, then the possibility of tension between law enforcement either engaging or disengaging or disentangling themselves from certain postures, and looking for ways to form common ground, to connect with the community, and communicate in word, policy, practice, deed, that what we say and what we do have congruity, and that they are consistent with the community core concerns and the community's core values.
Heather, can I come back to you for a second? I mean, I've been really intrigued about it because the Secretary said this twice today, that we'll only be focusing on serious crimes. That's the idea. If you really look at the memos, they don't say serious crimes. They say we will notify you about all felonies in the jurisdiction, convictions clearly, and all aggravated felonies under the INA, which is a large list of crimes. So are we really talking about large list of crimes, or are we talking about serious crimes, and what are the serious crimes?
Well, as we know, across the country, everyone's criminal code sections are different. And so the memoranda cannot be as specific to these crimes only. And so as a result of that, we use the term serious violent crime, but I also mentioned earlier about working with each jurisdiction to determine for that jurisdiction what crimes they will cooperate under the priority enforcement program. For instance, under the significant misdemeanors is DUI. There are a lot of jurisdictions that say we will not cooperate with DUI, but that doesn't mean they're unwilling to cooperate on someone who's been arrested for a serious felony, which we can all name serious felonies, and all of those charges are a little bit different across the country. But the key is there are many, many crimes, but we're not looking at very low-level crimes, and really the crimes that we're truly looking at are going to be unique to each jurisdiction.
So there's a lot of leeway now given to jurisdictions under this accommodation. So does that mean your sort of fortune is going to be determined as an unauthorized worker, whether you get caught in San Francisco or in Gwinnett County in Georgia? And is that good for national policy?
Well, I think the goal is to have as many jurisdictions as possible come back on board. But again, there is not a you shall. If there was a shall, it would be a whole different situation. And I think that many people across the country don't want to see you shall. They want to have some say over what happens all across the country because our communities are different. And so the key is for us to work closely with those individuals across our country and to make sure that people understand the the benefits and how PEP can assist in terms of a safe community for all of us across the country, wherever you are. Not to say that, if you don't participate, there's still a need to work together for safety with law enforcement. But it's a hard situation because we have no control at this point over all counties and states.
Yeah. Okay, I'll push you on one other thing on this. You mentioned the 2 forms that are in the regulations. I tell you, I've just heard this mostly from reporters, that there is a 3rd form called the X form. Is there a 3rd form which we don't know about? Or?
Under the PEP program, there are these 2 forms. I know that the department is looking at other alternatives, but at this point today, as we speak, there's not a 3rd form that's ready to be used or put out there.
Okay, so we'll just keep on.
That's all I can say. I know the 2 forms. Now, as we know, programs start, and we have to look at everything else that's out there and make sure that the program is working or improving.
So, Dora, I'm going to ask you this from the state perspective. It looks like now we're going to have a patchwork of different priorities around the country determined by the local culture of the place. Is that good from state point of view?
It gives the state the opportunity to have its own voice and to conduct its business consistent with the executive and legislative direction. So, from a local perspective, I think that it is there's advantage to it. Embedded in your question, depending on where you're living, though, is how you may fare, and so that presents again a challenge as to what might be fair in one place may be fundamentally unfair if you're intercepted in another location, and you can continuously read articles about someone who lives someplace but was traveling somewhere else and was intercepted.
So, Marielena, now respond to both the federal and the state law enforcement. So how are the advocates looking at this change? Is this just PEPCOM as against ESCOM, or is it something else?
That is definitely the way that the community experiences it. It's PEPCOM. There's a major trust deficit. I mean, that is basically the biggest problem. I think, Dora, you referenced to the larger issues. This isn't even just about immigration. There's a trust deficit between communities, especially poor communities and communities of color, and that includes immigrant communities vis-a-vis law enforcement. And unfortunately, I think the point that you made, Dora, is exactly it. The fact that PEP and ESCOM both require fingerprinting at the time of booking, it actually undermines the fact that PEP is supposed to apply only in a post-conviction world. Well, guess what? If you're in a place where local law enforcement fingerprints you and you happen to be brown and you happen to speak a different language or you speak with an accent or you have a particular type of name like Hincapié, you might be more of a priority, and then you get, then ICE gets notified, right? It really does completely undermine, I think, what the intention was to have this operate in a post-conviction world. So one is there's a major trust deficit. Second is perception is reality. So even if PEP may be, and I think, Heather, you've been involved in these negotiations, the intent of the administration may be good, but unfortunately, what people are experiencing on the ground is really different. And I was hearing Secretary Johnson this morning and even hearing you, Heather, and with all due respect, folks who are there are people with convictions that are getting deported. That is a priority now. But there are also many people who are still getting detained and deported with no convictions. And I'll just point you, some of you may have read the New York Times editorial last Friday. In southern Louisiana, 2 workers from Honduras standing outside of a motel, waiting to be picked up for a job, got detained by local police. They were in detention for 140 days. One of them was just deported last Wednesday, and on Friday, only after a big campaign by the New Orleans Workers Center for Racial Justice and a New York Times editorial, scathing editorial, pointing to the fact that the DHS Director of Civil Rights, Civil Liberties, found and emailed and contacted ICE and Border Patrol saying, you should not be deporting this person. This person should be, these 2 men should be released. You should have never detained them. It appears to be that it was racial profiling, yet they were deported. And that is what the community experiences, right? When people see that you can still be detained and deported for being brown and looking for work, there is no trust in ICE and Border Patrol. And so I think that is the greatest obstacle we have.
If I can jump in
Sure,
and just build on the conversation about trust, and it goes back to another question from earlier today about when the Secretary was asked about a recent report concerning the efficacy of the evaluations that are made of the detention facilities. And of course, the life in detention has been a subject of concern for quite a number of years and has made modest gains, being generous, I guess. And so fixing this program and having a successful transition from secure communities to PEP is crucial. I don't think anyone here doesn't appreciate the huge lift to narrow the focus from a population some 3 million in size down to something that's about half that, 1.4, maybe 1.5 million individuals, by having more specific guidance and clearly quite a bit of training and supervision of enforcement agents who use quite a bit of discretion before. And I guess the question is, how much discretion are they still using now? But my point is, I think even as you focus on fixing one of the things that's a hot damn, that there are all these other issues that are of great concern to advocates and legislatures alike. And so we need to be as broad in our focus. We got those of us in government to fix as many things as quickly as we can, and not just look and work on one thing at a time.
Cristina, you want?
Yeah, so I think that the transition to the structure of PEP highlights how, at some level, the goals of the immigrant advocacy community and DHS are just incompatible. The data sharing that continues is required by statute. So it's not as if DHS has a choice in that matter, at least the way the executive branch understands that statute. So then the question becomes, in immigration reform, do you target that data sharing? And I would expect that the advocacy community would say, yes, that's the problem. That's why people are afraid of the police. But DHS would say, no, that's an amazing tool that we have at our disposal to be able to identify the right people to deport. Otherwise, we return to a world that's much more ad hoc and where we don't have the information that we need to actually perform the enforcement function. And so there's an incompatibility or an incommensurability there that I'm not sure you can get past. I think maybe the only way to address it is through the kinds of adjustments that DHS is trying to make, and ongoing pressure by advocacy communities to say, here are the ways you can fix what you're doing, or here's where the problems are arising most saliently, so this jurisdiction needs to be better supervised than that jurisdiction. But at bottom, there is I think an ideological or just institutional disagreement about what the right thing to do is.
Talking about disagreement. I mean, I had to just wear your lawyer hat again for a second. I was very intrigued yesterday by two clippings that came to my attention at the same time. That immigrant advocates sued Dallas for violation of Fourth Amendment rights by holding people on longer under a detainer. At the same time, the Attorney General of Texas said that he was going to sue Dallas if they stopped becoming a sanctuary city. So there are these lawsuits now against places like this from both ends. And how does some place like Dallas deal with two ends of these legal challenges?
For me, I think so there are two ways of thinking about it. The first is that, and I'd be interested to know what people who've worked in state and local law enforcement think about this, but that whether the Attorney General or the state of Texas can force Dallas to comply is a question of state law, and it probably can force them to comply. But obviously the state can't force local jurisdictions to violate the Fourth Amendment. And so the question of whether the Fourth Amendment is violated is a separate one altogether that limits the ability of state or local, to cooperate with the federal government. And Heather might have views on this question, but it seems like what the federal government is doing by adding the probable cause component for the detainer is to insulate from Fourth Amendment challenge the state locals holding someone for those 48 hours. I think the question is whether state locals can do that at the behest of the federal government consistently with the Fourth Amendment. And I think there are probably arguments on either side. I'm not a criminal procedure expert, but that to me is the question, because DHS is trying to conform to those expectations. And the question is, what can states do within the parameters of the Constitution?
So Heather, I suspect could you also respond to Marielena's point about the trust?
Okay. With regards to the detainer form, that's why under the priority enforcement program, there is the request for notification. When a jurisdiction responds to that request from ICE, they don't hold that individual a minute beyond the time that they would otherwise be released. And so that's where the Fourth Amendment violation or concern wouldn't be raised. And so a lot of jurisdictions actually have gone to the notification, honoring those, and then it's up to ICE to basically make sure that they get there. And if ICE can't get there, then we have to figure out what we're going to do, because the goal is not to put state and local jurisdictions in a situation where they're facing additional legal action. The goal is to work with them to help them remove those individuals that they choose to turn over to us. So that's one. With regards to the community trust, I think coming from local law enforcement, community trust is very, very important at all levels, because they're the people that we serve. They're the people that we develop programs to work with. Now, the key here is, I think that we have to be upfront, telling exactly how these programs are, to work together so that people understand, may not agree, but at least to explain the program so that there's not misinformation being shared, and then to move forward hand in glove. But at the same time, when there are challenges that arise, that was mentioned here, we need to know about that so something can be done to address that. And oftentimes we will get calls from state and locals expressing their concerns about what happened and how they felt that they were put in a bad spot. And so anytime those scenarios come about, we look into them to figure out what to do, because at the end of the day, we need that community trust. We need the trust with our state and local colleagues, and we want the program to be successful. We don't want this to be a program that basically everyone's doing whatever they want to do and harming everybody. Mm-hmm. That's not the goal here. The goal is to work together to answer those problems that are problems and fix what needs to be done.
Moose, if I can just respond for a second, because I think last week's example of these two men is really, I think, emblematic of what we as immigrant rights advocates have to deal with, which is if you happen to have a good relationship with the editorial board of the New York Times and you can get them to run your story and you can put a lot of public pressure, maybe you will get someone released. But tens of thousands of other immigrants don't have that connection. They don't have an advocate. They don't have our telephone number at the National Immigration Law Center. We do often call everyone at DHS headquarters and ICE if necessary, but that shouldn't be the way our system works, right? It shouldn't require this level of campaigning to get both the federal government and the local law enforcement agency to follow the law and to follow the Constitution. One of these men was in solitary confinement last week for 3 or 4 days. How is it that this is a result of both the combination of PEP and the enforcement priorities and the communication locally, and even in a situation as egregious as this, and despite even the Director of Civil Rights and Civil Liberties saying to ICE Director Saldaña ignored that. So the fact that you've got different parts of the federal government not even listening to each other and not following the president's memo is really troubling, and that is what really undermines the trust issue.
So, Dora, I'm going to ask the last question before we go to the audience. And we understand that part of the PEP implementation is accommodating some jurisdictions that some ICE agents will now be at local jails. Which in many ways is sort of back to the old criminal alien program. How good from state perspective, is it a good idea for ICE agents to be in local jails?
I would say under certain circumstances. There's a core commitment as has been said today, where state and local and federal law enforcement agencies partner and practice with one another on a continuous basis. And so there is a core trust and respect amongst those organizations, which hasn't been said. But we also have fidelity to our jurisdiction. I'll toggle back to a New York City experience. I was newly arrived as commissioner in the city and observed that at the time ICE agents had free access to the jails. They were not required to wear an identifiable uniform or to even present a shield and identify themselves before they approached prisoners. And I had great concerns about that. And so we did not prohibit them from having contact, but we regulated that contact, requiring that they wear a uniform, that they have an agency ID, that they make a request of the department before they had contact with an individual, and that each of the individuals they wanted to see were advised in their own language that they could proceed, they could decline, or they could proceed if they had counseled that they, of course, would have to acquire at their own expense. And I think each place will figure it out in their own way. So you can cooperate, but I think you have to tailor it to the circumstances of the place where you are.
That's helpful. Okay, folks, members of the audience, any questions you have of any or all of the panelists? There's a hand here. Yeah. Reverend.
Yes, Father Ippolito, Catholic Charities, Raleigh, North Carolina. Thank you, Marielena, so much for your comments about the men on the street, because despite DHS's insistence that they're only deporting felons, the opposite is true. I have a client, recipient waiting a U visa, that was arrested for burglary, and immediately put a hold on him. I had to tell his criminal defense lawyer, keep him in jail because they're going to deport him. So thank you so much. You're absolutely correct, right on target. Thank you so much for your comments.
Thank you.
It's not a question, except as a compliment. Please go ahead.
Hi, good afternoon. My name is Claudia Flores, and my question is directed to Mrs. Fong. How much weight do older convictions play in prosecutorial discretion? We've seen cases where individuals who have very positive equities in their communities are still being targeted. And it seems to a lot of the advocates that a lot of the burden is falling on the immigrant and not so much on directing ICE officers to really understand what this memo means. So I'm just curious in terms of what you're doing to ensure that there is some sort of accountability on this. Thank you.
That's a good question. There are actually two angles to this. One is that the ICE supervisors have the authority and the discretion to make decisions on a case-by-case basis, because not all cases are the same. At the same time, we have jurisdictions across the country that are saying we will only honor notifications or detainers for these individuals or these types of crimes, but we will not go back for 20 years. We'll go back for 5 years or 7 years or 10 years. So that's also some of the discussion that's been happening at the various state and local jurisdictions.
So just to be clear, there is no standard guidance or a standard of review, if you would put it that way?
Well, for the
purpose of prosecutorial discretion.
Right, in terms of the supervisors, they do have discretion. Now, if I can't tell you, not being an ICE agent, I can't tell you the specific information about how they weigh that discretion, but I'm happy to find out and get back to you on that.
Okay, thank you.
And Moose, if I could just comment on that. I think the good and the bad, on the good news is that the new kind of approval process that's been set up is better in that you have ICE supervisors reviewing the request much faster. On the downside, usually what we've seen at this round is that the decision from the ICE supervisor is to actually approve the decision below, almost 9 times out of 10. I think the issue that Claudia just mentioned falls into the unless clause of the memo, which is that ICE agents should be looking at if they meet certain priorities unless they have these other equities. And looking at that, again, what we're seeing is, and it's the issue, I think the question you raised, Moose, like if you happen to get detained in San Francisco, it's a very different outcome than if you're detained in Riverside, California. And we're finding that more often than not, ICE, including ICE supervisors, including headquarters, are actually not taking into consideration the broader equities. They're not looking at the full picture of the individual.
So I see you, but would you mind if I give opportunity people who didn't ask questions earlier today? So please go ahead.
Thank you. My name is George Mann. I'm an immigration lawyer in the Detroit area, and I deal with the actual situations where clients who are detained call our office, and so I have, over a period of many years, some perspective about how things are changing. And I can tell you that basically the ICE agents, the so-called discretion that they have is basically means that any new policy that happens in a change of policy that comes down from up high only has a limited effect on what actually the agents are doing locally. And really there has been very little change. And in fact, in some cases, the priority 1 and 2 and 3 and so on, actually the agents are using it as a excuse for not exercising humanitarian discretion that they were exercising before. They're using it as the excuse, well, it's his priority so-and-so, and therefore, so the net result is that you basically have what I would consider rogue agents doing whatever they want, so long as they can justify it. And then when you want to, even when you have an outrageous situation and you want to bring public attention to it, it's a game of luck. If you are able to attract the attention of members of the press or community activists, and if they have enough time to mount a campaign, you can save the client sometimes. And if not, then you have a situation where a family with dire situations is broken up. And so it's not really, you have a lot of work to do.
Okay. Thank you.
Do you want to respond, or you think that's a recommendation?
Oh, no, I welcome your feedback because it's important for us to know so that we can do better. That's our responsibility.
But Dora, would you like to respond?
Yeah, just to turn it around a little bit, one of the other facets of PEP that hasn't really been touched on was recognizing that there was a history of the appearance of lack of transparency, and that reporting is a requirement of PEP as well. And so I think that Homeland and ICE have real opportunities in how they formulate their dashboard, hopefully with input from others, so that the issues that are of greatest concern to individuals can be examined. And some of it is not going to be simple metrics. Some of it may require some in-depth. So whether it's how frequently was discretion of what kind, up or down, exercised, might help to shed light and also improve your future training and supervision.
We got a question for one, so the young lady, the mic.
Thank you. My name is Majana, and I work with the National Domestic Workers Alliance. Marielena, thank you so much for the positive shout out for all of the organizing work that domestic workers across the country have been doing on a number of different fronts. My question is directed to you, and I was hoping you could talk a little bit about the harmful effects, particularly of family detention, and what that looks like when mothers and children are specifically being locked up in detention centers.
Sure. I had the very unfortunate experience to interview some of the mothers and children in Artesia, New Mexico last summer, and I have to say it was a horrific experience. The fact that we are locking up mothers who have escaped extreme levels of violence, whose daughters have either been raped or are being threatened with rape by gang members in their local communities, who are being told that unless they pay a $20,000 renta, they're going to have their whole family executed, that they're refugees. They are making a perilous journey to our country. And the fact that this administration has decided instead to lock these mothers up and these children up and further traumatize them is simply, it's un-American. I will leave it at that.
Okay, we wish we could go longer, but thank you.